frequently asked questions regarding effective and operative dates of California statutes. So what's an effective date of a statute? Well, a common definition of effective date is when the new law is on the books, basically. What is an operative date of a statute? A common definition of operative date is when the new law becomes operative or it's implemented. Now, sometimes this is commonly but mistakenly called when the new law is in effect. Can a bill create a delayed operative date? Yes, any bill can specify a delayed operative date. Do some bills take effect immediately? Yes, there are certain types of bills that are deemed to be in effect upon their enactment, which is when the governor signs them and the Secretary of State assigns a chapter number. Therefore, unless the bill calls an election, contains an urgency clause, is a budget-related measure, or a tax levy, the presumptive effective date is January 1 following the year of enactment. In terms of an operative date, what is the operative date? An operative date is distinguished from an effective date. For example, a 1956 California Attorney General opinion said a statute may be worded so as to provide for an operative date other than its effective date. So an operative date may be the same as the effective date, which is the most common outcome, or it may be different than the effective date. An operative date must occur after a statute's effective date. How have state courts viewed operative dates? According to a decision of the Court of Appeal in California, People versus Verba in 2012, the appellate court said, unlike a statute's effective date, which is determined according to immutable rules written into the state constitution, its operative date, the date upon which the directives of the statute are actually implemented, is set by the legislature in its discretion. So what's the general rule for the effective date of a statute? That rule is found in section 9600A, which provides that a statute enacted at a regular session shall go into effect on January 1 next following a 90-day period from the date of enactment of the statute, and a statute enacted at a special session shall go into effect on the 91st day after adjournment of the special session at which the bill was passed. Of course, this mirrors the same language in Article 4 of the California Constitution. Now, just like in Article 4, there are specified exceptions to this general rule, and they're also set forth in Section 9600B of the Government Code. And it says, like the Constitution, statutes calling elections, statutes providing for tax levies or appropriation for the usual current expenses of the state, and urgency statutes go into effect immediately upon their enactment. So what's an example of an effective date? Well, a non-urgency bill enacted, say, on September 5th, 2023, would take effect on January 1, 2024. A non-urgency measure that is enacted in the second year of the two-year session would likewise go into effect on January 1st following a 90-day period from the date of enactment. Now, for a statute enacted at a special session, those take effect on the 91st day after the adjournment of the special session at which the bill was passed. And finally, why does the California Constitution require most bills to have an effective date after 90 days? The delay in the effective date of statutes enacted at regular and special sessions provide that 90-day interval between the enactment date and the effective date, so that folks are permitted to circulate and present a referendum petition requesting that the statute or part of it be submitted to the electorate in an effort to overturn that statute.